Hello everybody, my name is Anju, Esther, Balakrishnan, legal intern of LEXIS and Company, and welcome back to this channel. Thank you for watching this channel. If you're not, press the like and subscribe button, please do that, and also click the notification button in order to get more law related videos in the upcoming days. In today's video, we're going to talk about Sales of Goods Act 1979. And the Sales of Goods Act is basically a British law that governs the contract of sales and purchase of goods. Basically, it serves a lot of different purposes. And we have to understand that if there is a buyer who wishes to purchase a particular good and there is a seller who wishes to sell the good for a compensation in return or for a fee in return, then there's an agreement or transaction between the both. And this sort of contract or agreement between the buyer and seller, where the seller decides to transfer his ownership of property to the buyer, is governed under the Sales of Goods Act. The Sales of Goods Act, we have the term goods. So basically, we have to know what is goods under the Act. So Section 61 defines the terms goods, where it states that all personal properties comes under goods. However, services or money or choices in action do not come under this category. Only personal properties come under goods. It's also stated under the section that crops or soil products basically can be considered goods because they are sold or they are supplied with an intention of severeness. So basically, they are severed or they're cut off, they are harvested before they're sold. So hence there's the intention of harvesting the particular products before the sale, and hence would be known as a good. However, it's also mentioned that if the crop is attached to the land, that is, a crop sold with the land on which they are grown would not be considered severed before sale or under the contract of sale, as required under Section 61. In order to explain that particular sentence, it basically means that if the crop is attached to the land, or if the vegetables, if the fruits, or if the tree, or basically if the product, the soil product, is attached to the soil during the sale, it is sold without an intention of severing the product for supply. So then it would not be considered as a good under Section 61. Section 61 states that soil products which are supplied with an intention of being severed for sale, with an intention of being harvested. That means those crops, those products, and those vegetables or fruits that are harvested with the intention of supply can be known as a good. However, if a land is sold with crops attached to it, it would not be known as a good under the Act. There are different terms implied under the Sales of Goods Act, and terms are always implicit when it comes to transaction. The same also happens during the Sales of Goods Act when things are governed by the Sales of Goods Act. If the defendant violates the terms and conditions of a sale of good, then in such situations they would be sued for damages. And in cases if the violation is so minor, is unreasonable, in such situations the non-consumer buyer can reject the product, saying that it does not meet the conditions or the terms for description, quality, fitness, or sample, and can be considered as a breach of warranty, and the buyer can sue for a breach of warranty. Section 13 subsection 1 states that when there is an implied restriction in a contract for the sales of goods by the description that the items must match the description, it should be, that requirement should be fulfilled. There's always a requirement in a contract, and that the description of the items must match the description. When you get the product, the description that you saw must match the product. It's always an implied requirement of a product, and that requirement should be met under Section 13 subsection 1. A sale by description occurs when the buyer buys a product based upon the description and has never seen an item. So when you hear something or when you read a description, you buy the product. Basically, online shopping can be sale on description, because you read the description, you read the reviews, You see the product, but you see the image of the product. You're not seeing the product directly. So I don't think it can come under sale of description because you don't see the product there. You just hear the description, you read the description, you buy the product. So you expect this item to match your description. And in that cases, there's a requirement, there's a term that the description needs to the description needs to match the item. In such cases, if the product that are picked or viewed by the consumer does not match description, the seller can be sued by the consumer. So basically, the Sales of Goods Act section, Sales of Goods Act section 12 subsection 1 and 2, section 13 subsection 1, section 14 subsection 3, and section 15 deposits the connection between the buyer and seller and addresses the issues such as the rights and obligations of the parties as well as the remedies that can be provided in cases of violation. It helps in assisting the consumer or the customer in protecting themselves from fraudulent cases or fraudulent situations. And because of such an act, the vendor has a tough time in defrauding their customer for their own benefit. So basically, the Sales of Goods Act protects the consumers and ensures that they are not fooled or they are not tricked in any manner, and protects them from any sort of fraudulent actions from the vendor. So it's important that you know about the Sales of Goods Act, and I hope that you could understand the act. If you liked the video and if you could understand the video, if you could understand the act, please press the like and subscribe button for more law related videos in the upcoming days. I hope that you're having a wonderful day and you would have a wonderful day ahead. Thank you for your time and understanding.